Santosh Anand. For the appellant, Mr. Salesh, Mr. Pratyush Lala, Mr. Deepak Kumar, Mr. Ashish Kumar. For the respondent.
May it please, Your Worship. Your Worship, this is an appeal filed by the insurance company. And the major point which we have taken is this is under 140, Lordship. In this case, in my humble submission, the lower court records would be necessary, Lordship. This was a contractor's.
Lalit Jadhav is appearing?
My Lord, I am appearing.
So this is a different case. So in this case,
My Lord.
Pratyush Lala and Deepak Kumar. Where is Pratyush Lala?
Yes, Lord, sir, I am.
You are for the owner?
No, I am not for the. I am for the claimant. For owner, Mr. Salesh is appearing. Mr. Salesh.
And you are for the claimants?
Yes.
Have you filed any application under 166?
My Lord, today in this case I have received only, my Lord, a limitation matter notice. The original order.
Limitation, I am considering it.
My Lord.
Yes.
7 days. IA number so and so. IA number 8665 of 2015. After hearing the counsel for the parties and after going through the records, I find that sufficient ground has been shown to condone the delay of 7 days in filing this appeal. The delay is thus condoned. First up, place this case under the heading for admission or for the lower court records.
My Lords, all
Meanwhile,
right.
Lordship, if possible, copy of.
हम दे देंगे, my Lords, हम दे देंगे.
In the meantime, counsel appearing on behalf of the claimant will inform this court as to whether the claimants have filed any application under section 166 of the Motor Vehicle Act or not.
Right.
Under the heading for admission, serial number 23, a passed over case, MA number 83 of 15, Mr. G.C. Jha, and for the appellant, Mr. Rajiv Kumar Karan, Mr. M.P. Lal, Mr. Lalit Yadav, Mr. Shiv Kumar Singh for the respondent. Yes. Yes, Mr. Jha.
Yes, Lordship. This is the case in which the petition under order for 16 Rule 6 has been filed. And at the time, the owner of the vehicle was not present in the first half, Your Lordship. That's why it has been adjourned for 215, Your Lordship.
Yes.
The counsel, Mr. Lalit Yadav, has already appeared.
Yes, Mr. Yadav.
My Lords, but I am appearing for the legal heirs of the deceased, my Lords, owner, my Lords.
Okay. It says that the driver was not holding a valid driving license. And this issue has been wrongly decided in paragraph 616. This is the case of Mr. Jha. What do you have to say?
So far, the my Lords, the query has been raised, my Lords. Even petition was filed, my Lords. Thereafter, by under order for direction upon the to produce the DL, my Lords. That petition, my Lords, came in advance, my Lord, and that was in wrongly interfered, my Lord, while deciding the dispute, my Lord. That has been raised, my Lord. But, my Lord, since the judgment was copy of the judgment, my Lord, I could not, since it is on.
Mr. G.C. Jha. The insurance company, I heard Mr. G.C. Jha. The insurance company has challenged the validity of the driving license of the driver of the offending vehicle. First off, he submits that an application was already filed wherein a direction was sought from the court to direct the claimant owner to produce the original driving license, but the said petition was kept in abeyance and no order was passed. So he submits that as prima facie, there was a report which was produced before the court, which suggests that the driving license which was produced by the owner is forged. the insurance company had filed the aforesaid application. He submits that without disposing the application and without considering the facts, the tribunal has wrongly decided the issue number 4 and 5 against the insurance company. First stop. Next para. On query, Mr. G.C. Jha submits that if this appeal is allowed, then it is held that the vehicle was being driven without a valid license, or without a fake license. The insurance company has a right to recover the said amount, said compensation amount from the owner of the vehicle. Yes, Mr. Jha?
Yes, Lordship.
Owner of the vehicle. Next paragraph.
Only I am mentioning the date of the petition, 19/4/2014.
On the date of petition, like filed a petition dated 19/4/2007.
14, Your Lordship.
2014. Considering the submission of the party petition appellant, this court is also the opinion that ultimately if this appeal stands allowed in favor of the insurance company, the insurance company at best can get a right to recover the amount of compensation from the owner of the vehicle. First up. Before proceeding any further to decide the aforesaid issue, I direct the insurance company to satisfy the award so that the claimants are not put to any loss due to delay in making payment in terms of the award. Full stop. List this case after award. Full stop. The next para. Considering the submission of the insurance company, this appeal will be heard. Admit no fresh notice to be issued. Rule returnable 6 months.
Lordship, we have already deposited 2,50,000. That should be adjusted.
Where have you deposited?
Yeah. For granting of a stay, Your Lordship, before the court below.
The amount deposited by the insurance company before the tribunal should also be disbursed to the claimants after proper verification.
And the rest of the amount before this.
Balance amount along with interest should be paid within 2 months, within 6 weeks from today.
Before the High Court, Your Lordship.
No, pay. You satisfy the amount to the claimants.
So that check should be deposited in many cases.
Give it to the claimants. Give it to the claimants.
The claimants have already appealed.
My
Lordship,
order is to satisfy the award.
Yes, Lordship. Before the court below, then.
You satisfy the award.
In many cases, Your Lordship directs us to file before the registrar, Your Lordship. That's why I am asking this question.
No. Why registrar? Why didn't bring in the registrar? What happens if an appeal is dismissed? What do you do?
Recovery, Your Lordship.
What do you do if an appeal is dismissed? Your appeal is dismissed. What do you do in a case?
Then
You go and satisfy the award. You satisfy the award.
yes, I am just asking.
How do you
I am
satisfy?
asking. I am just only asking where we should just deposit the amount.
What do you do when your appeal gets dismissed? What do you do if your appeal gets dismissed? Do the same thing. Yes.
No, Lordship, my query was that we have paid 2,50,000. Rest of the amount, whether we should deposit before this court, before the High Court or before the court below. That is only my simple question, Lordship. Because in many cases, Your Lordship directs us to file deposit here.
I am asking you in a case where your appeal of the insurance company gets dismissed, and you are directed to satisfy the award. What do you do?
Then before the court below.
Or what will be easier for you, Mr. Rajiv Karan?
My lord, we can provide the account number so that directly the amount may be deposited in the account of.
It will be better.
My lord. Then 1 week time I will provide the.
At this stage, Mr. Rajiv Karan submits that he will furnish the bank details of the claimant, so that the with the lawyer of the insurance company, to the lawyer of the insurance company, so that the insurance company may transmit the amount to the claimants directly. Full stop. It is therefore directed. It is there. Mr. Rajiv Karan is therefore requested to communicate the bank details of the claimant to Mr. G.C. Jha, who will forward the same to his clients and will instruct the client to transmit the entire amount along with interest in the account of the claimants.
Less amount already. Less
Yes.
amount.
Yes. The account of the claimants. Full stop. The proof should also be a proof of such payment should be communicated to the counsel for the claimants and also should be produced before this court. Yes, next.
But it should also be indicated that less the amount already paid here.
Yes, that is already there. I have said that the balance amount has to be deposited, which is deposited should be disbursed.
Yes.
Obliged. Much obliged.
Yes, next.
Regular cases under the heading for admission, serial number 27, MA number 600 of 16, Mr. Ashutosh Anand for the appellant, Mr. Vikesh Kumar, Mr. Jitesh Kumar, and Mr. Ajit Kumar for the respondents.
Please, Worship. Worship, this appeal has been filed by the insurance company, and on the last date, LCR was not received, Worship. So, adjourn हुआ था.
Yes, LCR has been received.
My lords, इसमें apart from various points, one important issue would crop up is whether the permit was valid and in effective or not. Your Worship, in this case, if your lordship would kindly turn to internal page number 5 of the award.
Yes.
In this case, in this case, no witness has been examined by the opposite party insurance company. From perusal of Exhibit A, it transpires that the permit has been issued in the name of Ranjit Kumar Ray in connection with vehicle number so and so, and it was for rural area of Jharkhand. It was valid from 8/8/13 to 4/7/13. ये हुजूर 8/3/13 होगा lordship. For the typographical error है. I've got the permit with me. 8/3/13 to 4/7/13. From perusal of the first behind, it transpired that accident took place at village so and so within the district of Saraikela. So I find that even as per the first behind, accident has not taken place in the town area. Accident took place on 6/8/13. Hence, I find that at the time of accident there was valid permit. Now, if your lordship will permit me to place the date of accident, that is on 2nd March 2013.
Date of accident?
2nd March 2013. If your lordship would kindly allow me to place the previous page, page number 4.
And the permit was valid?
From 8 March. Accident के बाद का permit है lordship.
2013 to?
ये 4 months के 3.5 months का permit लिया गया था. Sorry, 4 months से थोड़ा सा कम का permit लिया गया था.
This is the only ground.
Well, this is the major ground so far as permit is concerned against the owner. And lordship, apart from that, there are various grounds, lordship, but like lordship, contributory negligence is ground, my lords.
This accident took place on 6/8/13.
My lord, on 2/3/13, my lords.
2/3/13.
My lord. Internal page number 4.
You read that? You read that again?
My lord, internal page number 4.
You read that again from perusal of Exhibit A. It transpires that the permit has been.
From perusal of Exhibit A, it transpires that permit has been issued in the name of Ranjit Kumar Ray in connection with vehicle number so and so, and it was for rural area of Jharkhand. It was valid from 8/8/13 to 4/7/13. So this is 8/3/13 होना चाहिए. This is the first. From perusal of the first beyan, transpired that accident took place at village so and so. So I find that even as per the first beyan, accident has taken place in the town area, and accident took place on 6/8/13.
So this is wrong.
And
This is wrong.
my lord, if lordship will kindly turn to the previous page, page number 4.
LCR.
FIR लॉर्डशिप लॉन्च हुआ 19/3/13, तो किसी भी हाथ में एक्सीडेंट अगस्त का नहीं हो सकता है. Accident is of 2nd March 2013. फर्द बयान हुआ था 6 मार्च 2013 को, तो 6 मार्च की जगह 6 अगस्त लिख दिए हैं.
So this I find this finding is absolutely
perverse
and against the documents.
My lords.
So, yes.
My lords, and on kuch
Yes, Lord. But as per the claim application also, Lord, the accident took place on 2nd March 2013. As per the claim application.
So what about the permit?
Now, Lord, so far permit is concerned, Lord, it is also one exhibit A. I do not have the copy, Lord. Of course, as per the impugned judgment, I do not know the original. It might be on the record, Lord. Lordship may verify it from the record.
My lords, I've got a copy of exhibit A.
Date of accident?
2 March. Admitted है.
2013. 2nd March. There is no doubt about it. But that has been wrongly typed in the judgment, most probably.
There is some problem, Mr. Ashutosh.
My lords. My lord, exhibit A has been issued on 7/3/2013. Has your lordships got it?
And it cannot be from 8/8/2013.
Definitely, my lord. It is 8/3.
8/3.
And valid till 4/7. So this is a typographical mistake in the award, my lord. थोड़ा सा 3 को 8 समझ लिए because वहाँ embossing था, तो वो लग रहा है 8.
Oh yes.
My lords. But even otherwise, permit was not valid on the date of accident.
No. Whether there was any permit, whether this is a renewal of permit.
My lord, this is a temporary permit which has been specifically granted, my lord. It does not say it is renewal or not. Because this is the only document which is with the owner has filed.
Who is the owner of the vehicle?
My lord.
I am appearing for the owner.
Mr. Sani, if you have, so is this the permit or there was any other permit prior to this?
Right. I am not in a position because the judgment says about exhibit A only.
You just seek instruction.
Yes, ma'am.
Because the person has died. You know, the owner is no. The claimant has the husband of the claimant is dead.
Yes.
So you produce this document. It is you who produce this document.
The another plea which has been taken by the learned court below that no vague plea has been taken by the insurance in his written statement, and therefore it is not believable. Your lordship may kindly see the other part of the judgment, apart from the learned friend what he has placed in page number 4 with the last part, page number 5 minute. That I find that at the time of accident there was valid permit for flying the vehicle. Opposite party insurance company has failed to establish violation of terms and conditions of the insurance policy. So I find that the opposite party insurance company is liable to make payment of compensation, and the opposite party insurance company is not entitled to recovery right. Accordingly, such and such. Apart from this, the preceding page, that is page number 4, the towards concluding part.
Yes.
That I find there is no evidence of contributory negligence. That part, issue number 3, whether owner of the vehicle has violated any terms and condition of the insurance policy, including the requirement of the.
That is basing on the fact that the vehicle had a valid permit.
Yes.
Now, if the vehicle doesn't valid permit,
then in such case, only thing the recovery, otherwise recovery right.
Then
that's. But I am. Let me have the instruction whether it is the solitary permit or earlier to this, my lord, there had been any permit with the owner or not?
Mr. Sani pays for some time to seek instruction. Prayer allowed. Is this case after 3 weeks?
Obliged.
It is for the claimants.
I am appearing on behalf of the claimant, my lord.
Mr. Ashutosh.
My lord.
Satisfy award.
My lord, there was an order on 17/1/2019, my lord. Amount, perhaps we have deposited the entire amount and 50% was all to be released, my lords. I think this
71.
17 January 2019,
17/1/2019.
my lord.
First, look here. Considering the nature of argument by the parties, this court is of the opinion that if this appeal of the insurance company is allowed, at best the right to recovery can be given to the insurance company.
My lords, एक चीज बस हम बोले, my lords. इसमें we have also taken various other pleas, my lord, apart from this.
What are the pleas?
My lords, contributing negligence का plea है, my lords. Apart from that, because this is himself contributed to the accident, these are case, my lords. The second is, my lords, with regard to the aspect that
What is the evidence of contributory negligence which you have read? Then, like at best, right to recover the amount from the owner of the vehicle. Full stop. Next para. Considering the aforesaid, it will not be proper. It will be proper to direct the insurance company to. The entire amount has been deposited.
my lord, as per this, it
It will not be proper to deprive the claimants from the fruit of this award, as the entire amount of compensation has already been deposited before the
my lord, MSCT itself, my lords.
tribunal. Next para. Thus, I direct the claimants to approach the tribunal and pray for disbursement of the balance amount. First up, if such application is filed, the tribunal will disburse the balance amount in favor of the claimants after proper verification.
Obliged, my lord. Obliged.
My lord, and my lord, just one observation, because check to lapse कर गया होगा because MSCT court में नहीं होता है, my lord.
If a fresh check or demand draft needs to be issued, the insurance company will do the needful.
My lord, insurance company will cooperate, my lords. वो कर देंगे.
Will do the needful and cooperate.
My lords. Obliged.
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 Serial number 28, MA number 3 of 17, Mr. Alok Lal for the appellant, Mr. Jawahar Shah for the respondent.
In this case, we are challenging the liability. Manner of occurrence which
on behalf of the respondent, my lord. I have filed the IA in the direction of the chief, my lord. IA regard about the death of the respondent number 94. My I have stated for the
Mr. Shah, just a moment.
IA has been filed by me for deletion of name of the respondent number 1. That is IA number 270 of 2012, 22. Subject to correction 270 of 22.
This IA number 270 of 2022. Next, for the IA has been filed to delete the name of respondent number 1 from the cause title as he is dead. Respondent number 1 and 4.
legal heir of for the substitution of the name of the legal heir of respondent number 4, my lord. Rekha Devi and Arjun Kumar, my lord.
They are already
I stated in para 4, my lord, of my supplementary affidavit.
take down. IA number 270 of 2022. This
That is the respondent one only, my lord.
No,
I'm
who
not
has
aware of
filed
the
this?
four.
Who has filed this?
I have filed.
No, this is Jawad Shah has filed this.
Then there is one more I have for me, filed by me, my lord, for deletion of the name of R1.
This application has been filed. This
नहीं आ पा
application
रही है हुजूर
has been filed by the has been filed under
माइक प्लॉट का आवाज नहीं आ पा रहा है मेरे
Rule 10A of the CPC, informing that respondent number 1 and respondent number 4 is dead. First up, it has further been informed that legal heir of respondent number 1 is already on record as respondent number 2 and 4. First up, further it has been informed that respondent number 4 has has died. Respondent number 4 has also died, leaving behind his wife Rekha Devi and minor son Arjun Kumar. First up, this information as this IA be kept on record. First up. Yes, Mr. Alok Lal.
Yes. Well, in this case, we are challenging.
No, just a minute. You file a substitution petition first. Respondent number 4 is dead.
My petition seems to be only for one.
Where is it? IA number?
I was thinking that it was 720, but it seems that some other number is there.
No. No such petition has been filed.
Then, well, I'll file some. I'll file one.
At this stage, Mr. Alok Lal prays for 3 weeks' time to take appropriate steps. They are allowed.
For deleting 4 and 1, na?
Substitution of 4 and deleting 1.
Well, if my learned friends say who are the legal heirs, that would be easier for us.
You take out the photocopy of this order and you can find it.
Serial number 29, MA number 44 of 17. Mr. Alok Lal for the appellant, Mr. Kumar Nilesh, Mr. Sabyasachi for the respondent.
Well, in this case,
The claimant
I'm appearing on behalf of honor, Your Lordship.
There is a letter from the
now in this case, my lord,
Just a minute. Just a minute. What is this? Documents in original? Which documents were sent to West Bengal?
delay condone awaiting service report. My lord, paper cutting has been filed. Affidavit filed.
लिखिए तो by order dated 16/1/2020, this court has already accepted the service of notice upon respondent number 4 as valid. So, stop that being so, no fresh steps need to be taken in respect of service of notice to respondent number 4.
Lordship, I'm appearing on behalf of opposite party number 4, Your Lordship.
Oh, you are already appearing on behalf of Ganesh Kumar and Company.
Your Lordship.
All validly accepted. Full stop. Mr. Sabyasachi submits that he appears on behalf of respondent number 4. Full stop. Yes. Now, what is it?
Now, this is an appeal by the insurance company. We are challenging the liability on two counts.
Yes.
Firstly, the fact of the case is that these all three police constables, they were traveling on a scooty. This was dashed by the vehicle insured with us. Now, in this case, during the course of trial, owner has not appeared. We have taken a specific defense in paragraph 10 of paragraph 2 statement. To the still, it has not been filed, was not filed during the course of trial also. But kindly come to paragraph 11 of the award. The learned tribunal has held that defendant one of the owner
Yes.
that did not appear. Despite the notices, number 2 has contested the case and that the owners was on defendant number 2 to prove that there was a violation of policy condition, insurance policy. No evidence has been on record by defendant 2. The claim that there is a violation in terms of condition of the insurance policy. Therefore, presumption would go in favor of the claimant. There is no violation of the conditions
This
of
appeal
policy.
is at the behest of the insurance company. First up, the insurance company claims that there was a violation of the condition of policy as the vehicle was being driven without a permit.
Yes.
May I submit, Your Lordship?
So unless and until the owner comes and discharges his burden by producing his document,
To appreciate the
Your
aforesaid,
Lordship.
just a minute,
Your Lordship.
appreciate the aforesaid submission, it is necessary to go through the lower court record and the pleadings of the insurance company. We'll stop call for the lower court records.
Your Lordship, if I may be permitted, I can file my reply, Your Lordship.
What reply? In an appeal? What reply?
Because, Your Lordship, I could not participated in the lower court, Your Lordship.
Did not
They have
participate
every
or you did
document,
not participate?
Your Lordship.
You could not participate or you did not participate?
I could not, Your Lordship. No information was to us, Your Lordship.
To file an appropriate application. Let me go through the lower court record,
Your
we are
Lordship.
pleading, whether he has taken this point or not.
Your
Yes,
Lordship.
statement. Call for the lower court records. List this case immediately after receipt of the lower court records.
Serial number 30, MA number 604 of 17, Mr. Arvind Kumar Lal for the petition, for the appellant, Mr. Alok Lal, Mr. Prashant Kumar Rai, Mr. Santosh Kumar for the respondents.
Yes, Mr. Lal, same prayer.
in this case, Mr. Arvind Kumar Lal is there, but I have discussed with the officers of the company, Universal Sampo, their element settled, there seems to be element of compromise, Your Lordship. But Mr. Lal
Yes.
is not here.
You are on behalf of?
I am on behalf of the Universal Sompo Insurance Company Limited.
Mr. Alok Lal, appearing on behalf of the insurance company, submits that there is a possibility of settlement.
Yes.
Considering the aforesaid submission, when is the next Lok Adalat? In March?
No idea, Your Lordship.
List this case after 2 weeks or 3 weeks under the heading for orders, when the parties will inform as to whether the matter can be settled or not, whether the claim can be settled or not by mutual consent.
I have received instruction that you can go for settlement.
Right? You talk to him.
I'll talk because his mother has
That
expanded.
is why I have kept it after 3 weeks. That is why I have kept it after 3 weeks.
I'm not disturbing him for these small matters.
That is why I have kept it after 3
Yes.
weeks.
Yes.
Serial number 31 with serial
Madam,
number
Madam, for the respondent,
Mr.
1 to
Nikhil
7.
Ranjan for the appellant, Mr. Ashutosh Anand, Mr. Rohit Ranjan Sinha, Mr. Manoj Kumar Das for the respondent first case, and MA number 83 of 2018, serial number 32, Mr. Ashutosh Anand for the appellant, Mr. Rajiv Anand, Mr. Rohit Ranjan Sinha, Mr. Manoj Kumar Das, Mr. Nikhil Ranjan for the respondent.
May I humbly submit, my lord? I am appearing for the truck owner, my lord. By last order, my lord has been pleased to call for the LCR, my lord. In the original proceeding, I could not participate, my lord, and my lord, I have not seen the LCR, my lord, which will be required in the interest of justice, my lord. Kindly grant me only 1 week time. I will see and assist properly, my lord.
Yes, Mr. Ashutosh and Nikhil.
Your Lordship, this matter, Your Lordship, I have preferred the appeal for enhancement on 2 grounds.
No,
Firstly,
he's the owner. He's praying for some time to go through the lower court records.
my lord,
What do you have to say? He's praying for a week's time.
as Your Lordship pleases, my lord.
Because the counsel appearing on behalf of the owner prays for a week's time so that he can go through the lower court records and assess this court properly. They are allowed to this case after 1 week.
Much obliged, man.
Serial number 33, MA number 56 of 18, Mr. Chandrajit Mukherjee, Mr. Anjani Kumar, for the appellant, Mr. K. Ray, for the respondent.
My lords, in this case, I was praying for not today, your lordship.
Yes, Mr. Rai.
I'm appealing for the respondent.
You are for the claimant.
I'm for the respondent, Your Lordship.
Respondent claimants.
Lordship, it's a probate proceeding. It arises out of a probate proceeding.
This is serial number
33, Your Lordship.
33. This is a probate.
Yes, Your Lordship. Probate has been granted in my favor.
So what is the ground of challenge?
They have challenged on the ground that the testator himself did not have any title over the property, which was bequeathed by way of the will. That is precisely their main point.
Where is the judgment? Where is the judgment?
The judgment is at page 21, Your Lordship.
No. Where is the judgment of the Supreme Court that in a probate proceeding the title can be seen whether the person has?
Yes, that is the case, Your Lordship. The title cannot be seen in a probate proceeding.
So where is your
Lordship, as per my knowledge, the probate case was converted into title suit.
What do
If
you mean by-
I'm subject to correction.
What do you mean by title suit? Is that the title suit to declare a right title interest in any property? Title means what?
Lordship.
Do you mean to say it was converted into a title suit? That means the court has the right to see the title. Title means a landed property, title of the land or the property. It is converted. See, a probate proceeding is converted to a title suit when it is by a way of a procedure, when the will is contested.
Lordship.
Now, in a probate case, when a will is contested, it is the court which has to see whether the will is genuine or not, and whether it has been executed with undue influence or this. It is the title of the will is to be seen, whether it is correct
Yes,
or not, the title of the property.
Lordship, in running internal page 7 of the judgment, running page 27, para 12.
Yes.
The learned court bill has taken note the judgment of the Honorable Apex Court, reported in 2007, volume 11, SEC page 357, to that effect. He has quoted that, Your Lordship.
Lordship, I was praying that it may be kept in the next week. I will
Just a minute, Mr. Counsel. Suppose a property which doesn't belong to you, you execute a will.
Lordship.
Will the title transfer? Will it? Can you transfer a title of a property which you are not holding?
No,
What you can transfer? You can transfer what you have. You cannot transfer what you don't have.
Lordship.
So then in this case, what will be the will? Will be a mere paper. Suppose you by will you bequeath Taj Mahal to Mr. Krishnadura. Will Krishnadura become the owner of Taj Mahal just because of the will?
No, Lordship.
So your will may be genuine. So
Lordship.
suppose you frame that will in your sense. There are 3 doctor evidence. There are 3 other evidence and everything. There is no problem with that will. It is a perfect genuine will and registered also. But can you try by the will may be genuine, but by the virtue of that will, can you transfer a property which don't belong to you?
Lordship. No, Lordship.
So similarly, if this will is there, The genuineness court declaring that the will is genuine, that doesn't mean that court is finding and giving any finding in respect of a title of that particular property involved in the will in favor of any person. You can very well challenge that.
Yes.
If you think that this property by no means the person who is executing the will is the owner or the title holder of the property, you can challenge the same. That since X did not have any title, he could not have transferred the title to Mr. Ray. That is always open under the challenge. Mr. Ray cannot take a plea that his will was probate was granted in respect of the will, so the property will be mine. He cannot take that plea in that proceeding. This is the law. So, Mr. Ray, after 1 week?
Yes, Your Lordship, no issues.
LCR is here.
No, Lordship. When that
I'm calling for the LCR, so if possible, it can be disposed of at this stage.
Yes, Your Lordship, certainly.
Call for the lower court records. Full stop. Prayer has been made to adjourn this case. Prayer for adjournment has been sought for by the counsel for the appellant. Prayer allowed.
Oh, bless.
Serial number 34, 64 of 18. Mr. J.N. Upadhyay, Mr. Navneet Saheb for the appellant, Mr. Prashant Kumar Srivastava, Mr. Pratyush Kumar for the respondent.
Yes, what I may pay for the appellant, my lord.
Yes.
The order challenge of 40% deduction of the award amount, my lord, due to corporation negligence of the part of the deceased.
So, contributory negligence.
Yes, my lord.
LCR is here?
Yes, my lord.
Yes. You collided with a stationary truck.
Yes, my lord.
Are you?
Kindly see my lord, page number 26, my lord.
Yes.
Judgment.
Yes. Yes.
What
is the issue of contributory negligence?
Issue has not been framed.
Issue is annexure 1. Issue is there.
Yes.
Come on, refer to the evidence and tell me.
Only last occasion where order dated insurance company order dated 9/7/21 my lord, insurance company claimant has produced the document of Dayamati Sundi, my lord. Last occasion, my lord. 9(7) की last para, my lord. Learned Counsel Pratish Kumar appearing on the behalf of the National Insurance Company insured the offending the truck bearing registration of Itna has been submitted that the evidence of the claimant Jayamati Sundi is necessary to proceed for coming to a just finding.
So LCR is here, you argue.
Yes, my lord.
How this is not a case of contributory negligence, and what should we argue? You argue. This is not a bail application.
No, my lord.
Argue.
Yes, my lord. Kindly page number 6, my lord, 26, my lord.
Yes, page number 26.
AW1, my lord. Middle portion, my lord.
AW1, middle portion. From where are you reading?
1, 2, 3, 4. 17वां line, my lord. 17 line.
Internal page 7 of the judgments.
The internal page 6 of the judgment, my lord.
It's 26. Yes, in the deposition of AW1, clearly admit that. Yes, read that.
AW1 clearly admits that occurrence took place of the 13/12/14 is deceased Lalsul Sundi along with his wife Damayanti Sundi was on the motorcycle number MP12F 6558 of going to his house of the Govinda in Jamshedpur at the normal speed. Normis and about 6 being a drive racely and negligence sudden stop in the middle of the road is negligent manner blocking and the road without any indication of the parking light and without use back and side light indicator on which due to dark night the deceased Lal Subsidi lost the balance of his motorcycle and dress and the sad truck from the behind and Lal Sundi along with Damantu Sundi fadden down on the road and cause of grievous injury to him and his wife. Both were taken to TMH hospital for treatment, but Lal Sundi died in course of treatment on 15/12/14. As such, AW1, who is the applicant on the case and victim injured and clearly admitted that the 10-wheeler truck bearing registration number JH was in the standing position and deceased duty of the vehicle driver to use the road trekking proper care and not to dash the vehicle when the drive in speed race and negligence manner. I find further force of the argument landed counsel for the insurance company that the deceased was the driving on the resilient that they could not control the vehicle. This is a finding.
Yes.
Yes.
Substantiate your claim that this finding is wrong. Then only.
Yes, my lord.
Yes.
Kindly see me have AW1 का statement, my lord.
Yes, AW1.
LCR, my lord.
LCR AW1.
हाँ, AW Devan Sundi का, my lord.
Just a minute. Just. Where is the evidence? Yes, read the evidence AW1.
Yes, my lord. यह है कि मैं इस मुकदमे का आवेदक हूँ। यह है कि मृतक लाल सिंह सुंडी मेरे पति थे जिनकी मृत्यु दिनांक 15/12/2014 को मोटरसाइकिल दुर्घटना के कारण टीएमएच अस्पताल में जमशेदपुर में हो गई थी। यह कि दिनांक 13/12/14 को मेरे पति मृतक लाल सिंह सुंडी अपने मोटरसाइकिल से अपने गांव ललसीता थाना मुंशी सरायकेला अपने वरदा थाना टेलको स्थित अपने घर आ रहे थे। मोटरसाइकिल साधारण गति में थे। मेरे पति चला रहे थे। समय लगभग 7 बजे हम लोग नीलजड़ी टाटा हाथा रोड स्थित बाबा होटल के नजदीक पहुंचे थे। एक 10 टक्का ट्रक जिसका नंबर इतना है, उसके चालक द्वारा काफी तेजी गति से एवं लापरवाही से चलते हुए अचानक बीच रास्ते में बेकिफ तरीके से रास्ता ब्लॉक करते हुए खड़ा कर दिया बिना किसी पार्किंग लाइट के इंडिकेशन से। उसके कारण मेरे पति का मोटरसाइकिल से नियंत्रण खो गया और उस ट्रक के पीछे से धक्का लग गया और हम लोग रास्ते में नीचे गिर गए, जिससे हमें गंभीर चोट आई है और हमें इलाज के लिए TMH अस्पताल भर्ती किया गया है। यह है कि जख्म ठीक है, लेकिन इस क्रम में मेरे पति की मृत्यु हो गई। उस दुर्घटना का एविडेंस है मिलो। साधारण गति से हम चला रहे हैं, कोई नेग्लिजेंस ड्राइविंग नहीं है मिलो।
How many witnesses are there? Only one.
Only one, my lord.
Yes, insurance company.
Lords.
Yes.
Lords, the vehicle was standing in the middle of the road.
How?
There was no park. There was yes,
How
that was a negligent act, but the tribunal has also considered the fact.
Read this word. The counsel for the appellant has read. Read this statement of PW1, claimant witness 1. I am reading it for you if you don't have it. बाबा होटल के नजदीक पहुंचे तो एक 10 चक्का ट्रक, just listen to me, are you, am I audible?
Yes.
एक 10 चक्का ट्रक जिसका नंबर स्वयं को उक्त चालक द्वारा काफी तेजी एवं लापरवाही से चलाते हुए अचानक बीच रास्ता में तरकीब तरीके से रास्ता ब्लॉक कर खड़ा कर दिया. That means it was going and suddenly it stopped.
Now, if your lordships, because
now just tell me, can there be any other interpretation of this statement? Here I am reading it. द्वारा काफी तेजी एवं लापरवाही से चलाते हुए अचानक, the word अचानक माने suddenly, बीच रास्ता में तरतीब तरीके से रास्ता ब्लॉक करते हुए खड़ा कर दिया गया. What does this mean? How can this be interpreted? Tell me.
Yes, lords. Now, lords, the only thing to be considered by your lordships would be that some amount of contributory negligence would also apply because
negligence.
Subject to your lordship's kind consideration, because in a highway there is a minimum distance which has to be followed, lords, by a person exercising reasonable care and caution.
What is your cross-examination to that effect?
Lords, we don't have cross-examination.
I don't think so. You have cross-examined even. You have not also cross-examined.
Lords, may I just rely upon one judgment, Lord, subject to lordship's kind consideration?
Each judgment will depend upon each facts.
Yes, certainly.
The judgment,
that was a case which was parked. No, your lordships,
the judgment which you will show, if it is a parked vehicle and it was kept parked, then the matter is different.
Different.
Going through the judgment, I had got an impression that the vehicle was parked. But after reading this evidence, something else comes out.
Yes, lords. Comes out something else.
So I'm
Madam Lords, kindly, Lords, may I submit one thing, Lord, subject to lordship kind consideration? Yes, Lords, if your lordship sees the income which has been taken is the pension. The person who was a retired employee from bank, he was receiving pension. Now there are, yes, Lords, there are catena of decisions of the Honorable Supreme Court which says pension is not an incidence of accident, it is an incidence of service, and as such cannot be taken into consideration for compensation.
It is
Now,
not an appeal.
No, I am not in appeal, but your lordships may kindly appreciate that in view of Order 141, Rule 33, in view of Ranjana Prakash case, 2007, Volume 13, SEC, page 639. 2011.
Yes.
Just a moment, Lord, sir. It's I'm just giving citation. Lord. It's Ranjana Prakash. I'm just giving citation, Lord, sir.
Yes.
2011, volume 14, SEC, page 639.
Yes.
Now, Lordships, that was a case where the learned tribunal had awarded compensation and the insurance company had gone in appeal before the Honorable High Court saying that income tax at the rate of 30% ought to have been deducted. Now, the claimant as a respondent before the Honorable High Court in that case contended that, look, 30% future prospects ought to have been considered. The Honorable High Court in the appeal preferred by the insurance company reduced the compensation and did not look into that aspect that whether 30% ought to have been granted by the learned tribunal. Now, when the matter came before the Honorable Supreme Court at the instance of the claimant, then, Lords, certain paragraphs of the judgments are very important, Lords. May I be permitted to read out the same, Lords?
Yes.
The Honorable Supreme Court has said,
yes,
we are of the view, para 6. My Lords is getting that judgment?
Yes.
We are of the view that the High Court committed an error in ignoring the contention of the claimants. It is true that the claimants had not challenged the award of the tribunal on the ground that the tribunal had failed to take note of the future prospects and add 30% of the annual income of the deceased. But the claimants were not aggrieved by 23,134 being the taken as monthly income. There was therefore no need for them to challenge the award of the tribunal. But where in appeal filed by the owner insurer, if the High Court proposes to reduce the compensation awarded by the tribunal, the claimant can certainly defend the quantum of compensation awarded by the tribunal by pointing out the errors or the omissions of the award, which if taken note of would show that there was no need to reduce the amount awarded as compensation. Therefore, in an appeal by the owner insurer, the appellant can certainly put forth a contention that if 30% is to be deducted from the income for whatever reason, 30% should have been added towards future prospect so that the compensation awarded is not reduced. The fact that the claimants did not independently challenge the award will not therefore come in the way of the defending the compensation on other grounds. It would mean that in an appeal by the owner insurer, the claimants will not be entitled to seek enhancement of compensation by urging any new ground in absence of cross appeal or objection. This principle also flows from Order 41 Rule 33 of the Code of Civil Procedure, which enables an appellate court to pass any order which ought to have been passed by the trial court and make such other orders as the case may require, even if respondent had not filed any appeal or cross objection. The power is entrusted to the appellate court to enable it to do complete justice between the parties. Order 41 Rule 33 of the code can, however, be pressed into service to make award more effective or maintain an award on other grounds to make the parties to litigation to share the benefits of the liability, but cannot be evoked to get a larger or higher relief. For example, where the claimant seek compensation against the owner and the insurer of the vehicle, and the tribunal makes the award only against the owner on an appeal by the owner challenging the quantum, the appellate court can make the insurer jointly and severally liable to pay the compensation along with the owner, even though the claimants had not challenged the. Now, there are para 8 is very important. Where an appeal is filed challenging the quantum of compensation, irrespective of who files the appeal, the appropriate course for the High Court is to examine the facts and by applying the relevant principles determine just compensation. If the compensation determined by it is higher than the compensation awarded by the tribunal, the High Court will allow the appeal if it is by the claimants and dismiss the appeal if it is by the insurer owner. Similarly, if the compensation determined by the High Court is lesser than the compensation awarded by the tribunal, the High Court will dismiss any appeal by the claimants for enhancement, but allow any appeal by the owner insurer for reduction. The High Court cannot obviously increase compensation in an appeal by the owner/insurer for reducing the compensation, nor can it reduce the compensation in an appeal by the claimant seeking enhancement. Now, my lords, my respectful submission is, once it is a settled law that pension cannot be taken as compensation and 21 lakhs and odd has been granted, now, my lords, he states that on account of contributory negligence, certainly there is a finding which he opens to challenge it up the same. Now, my lords, in my respectful submission, had the pension not been taken at all, and in view of the catena of decision of the Honorable Supreme Court, right from 99, Helen C. Rebola case, thereafter 2007, 2016, 2019, 2020, all have consistently held, because I can give citations and I'll give citations as well. Now, they have consistently held that pension is not an incident of accident. It could not have been taken into no, because he has already benefited the just compensation much more than just week. There is a bonanza for him now, right now, because.
Well, how are you saying this?
No, if Lordship sees the judgment, Lords, of the Honorable Supreme Court 2019, 2019, Volume 17.
What happens when a pensioner dies?
Lords, if a pensioner dies, then if he is not working, then pension cannot be taken.
Just tell me one fact.
Lords,
if a pensioner dies, suppose if a pensioner dies,
yes, Lords.
The family pension is half of the pension which the original pensioner gets. The amount is reduced drastically.
But that is the law which has been declared by the Honorable Supreme Court. That has not to be taken into consideration, because
was this aspect considered? What happens when the pensioner dies, and what will be the financial impact of a pensioner who is dying in a motor accident, upon his wife?
Lords, as far as if the family pension is reduced from the actual pension, then there can be a circumstance. But if there is, but only to that aspect of reduction, Lords. But the entire amount cannot be taken, Lords. In my respectful, if your Lordship sees 2019 Volume 17 SEC 465.
Yes.
1917 SEC 465. May I just?
Yes.
Para 6 to 12 and 14, Lords.
Yes.
May I just?
What is the gist of it? Tell me.
Lords, in this case, there were some employees compensation, employee scheme insurance amount had to be paid under some scheme.
Yes.
Now, employees family benefit scheme. Now, while interpreting that, the Honorable Supreme Court has also considered the aspect of pension also, which would be relevant from page paragraph 6 to 12.
Yes.
Para 6 says, in Helen C. Rebolo's case, this is 99 old first judgment on.
You are reading.
Para 6.
In SCC.
2019 Volume 17 SEC 465.
Just a minute. 2019 Volume 17.
17.
17.
SEC 465.
465.
Sebastian Lakra versus NIC.
Paragraph
6 to 12 and 14.
Yes, come to paragraph 6 to 12 and 14.
Lords, in Helen C. Rebolo's case, the issue was whether the amounts received by the deceased by way of provident fund, pension, life insurance policies, and similarly in cash, bank balance, shares, fixed deposits, etc., are pecuniary advantages received by the heirs on death of the deceased and liable to be deducted from compensation. So here it was considered whether it is to be deducted.
Yes.
Now here what has been done is, here it is made the basis of compensation. When the Honorable Supreme Court says it cannot be taken note of, it cannot be deducted. So if it cannot be deducted, certainly it cannot be also.
No.
It cannot be made basis for compensation.
No, tell me what will be the basis of compensation of our retired.
One more judgment, Lords.
Yes.
2020, volume 11, SEC, page 356.
2020.
Volume 11.
2020.
11
SEC, page
356. NIC versus Birender karke ko. Lords, in this case, 7,000 was the pension which was being earned by him, along with some other income.
Yes.
The other income which he was earning was taken by the Honorable Supreme Court for compensation, for computation of compensation, but 7,000, which was the pension amount, that was not taken into consideration, because it cannot be taken into consideration. The relevant paragraph is paragraph 21 of that.
Read that.
Yes, please. Paragraph 21. Be that as may be, the tribunal for excluding the amount received by the deceased as family pension due to demise of a husband had noted in para 26 as under. The learned counsel for the claimants further requested that about to family pension being drawn by the deceased also be calculated for the purpose of assessing the compensation. The contention and assertion of the learned counsel for the claimant does not carry any conviction with the tribunal, because the deceased was getting family pension on her own right as the widow of the deceased and cannot be termed as her income for the purpose of computing the amount of compensation. The High Court, without reversing the said finding, proceeded to include the amount of rupees 7,000 per month received by the deceased as pension amount after the demise of her husband. We are in agreement with the view by the learned tribunal, and for the same reason have to reverse the conclusion recorded by High Court to include the said amount as loss of dependency. That would not being taken into account, as the same was payable only to the deceased being the widow, not her income as such, for the purpose of computing the amount of compensation. Now let's.
Mr. Counsel.
Yes, Lords.
You are just taking one or two paragraphs. Go to the basic facts. In this particular case,
yes, Lords,
deceased was a pension holder lady. And
yes,
both sons were major. Their claim was that my mother was getting 7,000 rupees as pension, so that also should be added, taken into consideration. This fact, here the claimant is the lady who is the widow.
No, Lords, in that case also.
Come to paragraph 2. The
disease,
wherein who are the major sons of Suneri Devi, the deceased.
Yes.
The deceased was getting pension.
The deceased was getting family pension. Here the deceased was getting pension.
The claim application was filed by the major sons.
Yes, Lords, here there is a widow which has come before your Lordships.
Absolutely different on the facts of this.
No, but the main principle of law would flow out, Lords, subject to.
The principle of law flows out from the facts of this case. There cannot be any straitjacket law.
Lords, if your Lordship sees that judgment, which I have 2019-17.
Show me a judgment where a pensioner is dead and the widow claims, and the Supreme Court says the amount of pension should not be considered for calculating the compensation. Show me.
Lords, if your Lordship sees that 2019 judgment, para 6 to 12, that is because I have researched, Lords. These are the judgments on the pension, Lords. There are no other judgments. But I have to rely upon these judgments.
The word pension and searching will not help. It should go with the facts of every case.
Lords, I think, Lords, subject to Lordship's kind consideration, if your Lordship sees the 2019 judgment.
Let us come again to 2019 judgments.
Yes, Lords.
That is 2019.
19, 17, Volume 17, SEC 465.
2019,
Volume 17,
volume 17.
SEC 465.
For
465.
465.
Plus, this is Sebastian Lacra versus NIC, para 6 to 12 and 14. I just began para
Para
6.
6 to 12 and something. What is the facts again? Come to the Sebastian Leclerc case.
Plus, in this case, there was a scheme for
Supreme Court says if a deceased dies and there is any scheme by the employer giving benefit,
that
those cannot be considered. That means those amount cannot be deducted.
That cannot be taken.
That cannot be deducted from the compensation amount. That cannot be deducted. That means those are independent. Those are over and above the compensation which they are entitled to receive.
Yes, yes.
That means what does it mean? That means the person is entitled to receive both amounts.
Yes, independently, my lords. Not under the Motor Vehicle Act. If your lordship sees para 6 to 12.
See, for the purpose of Motor Vehicle Act, Motor Vehicle
The compensation,
the amount which the employee is given should not be deducted.
Should not be deducted, meaning thereby what has to be assessed in accordance with the principles of computation under the MV Act should be computed, and those
What will be the
benefits.
income of the deceased? What will be the income of the deceased?
Lords, in this my respectful submission, since he was not working, then lords only general damages should have been given, conventional heads.
Sorry.
If your lordship just relies upon, may I be permitted to place para 6 to 12? It will take some time, or your lordships can go through them if you lordship.
No, read it. I have lot
Much of it. In Helen C. Rebello's case, the issue was whether the amounts received by the deceased by way of provident fund, pension, life insurance policies, and similarly in cash, bank balance, shares, fixed deposit, etc., are pecuniary advantages received by the heirs on account of death of the deceased and liable to be deducted from the compensation. This court held that these amounts have no correlation with the compensation receivable by the dependents under the Motor Vehicle Act. Following observations were made by the court. So broadly, we may examine the receipt of provident fund, which is a deferred payment out of the contribution made by the employee during the tenure of the service. Such employee or the heirs are entitled to receive the amount irrespective of the accidental death. This amount is secured. It cannot be. It is certain to be received. Where the amount of under Vehicle Act is uncertain and is receivable only on the happening of the event of accident, which may not take place at all. Similarly, the family pension is also earned by an employee or the benefit of the family in the form of the contribution in the service in terms of the service conditions. Receivable is service condition receivable by the heirs from after his death. The heirs receive family pension even otherwise than the accidental death. No correlation between the two. Similarly, life insurance policy is received either by the insured or the heirs or the insured on account of the contract with the insurer for which the insured contributes in the form of premium. It is receivable or even by the insured if he lives till maturity after paying all the premiums. In the case of death, the insurer indemnifies to pay the sum to the heirs again in terms of the contract or the premium. Accidental death, but otherwise on the insured's death is only a step for or contingency in the terms of the contract to receive the amount. Similarly, any cash, bank balance, shares, fixed deposits, etc., though all are pecuniary advantages received on by the heirs on account of one's death, but all these have no correlation with the amount receivable under statute occasioned only on account of accidental death. However, such an amount come within the periphery of Motor Vehicles Act to be termed as pecuniary advantage liable for deduction. When we seek the principle of loss and gain, it has to be on the similar and same plane, having nexus inter se between them, and not to which there is semblance of any correlation. So the insured deceased contributes his own money for which he receives the amount which has no correlation with the compensation computed as against the tortfeasor for his negligence on account of the accident. As aforesaid, the amount receivable as compensation under the Act is on account of the injury or death without making any contribution towards it. Then how can the fruits of an amount received through contribution of insured be deducted out of the amount receivable under the Motor Vehicle Act. The amount under the Act he receives without any contribution as such. As we have said, the compensation payable under the Motor Vehicles Act is statutory, while the amount receivable under the life insurance is a contractual. Now, thereafter, Lord Patricia Jean Mahajan case, the deceased was a doctor practicing in United States of America. He died on a visit to India. His wife had received an amount of $250,000 on account of his life insurance policies of the deceased. She had also received unemployment allowance for 8 to 9 months, and it was urged that these amounts should be deducted from the compensation urged. After referring to the entire law on the subject, including the decision in Helen C. Rebello case, this court held as follows. Now, thereafter, Lords, the same paragraph, Lords. We are in full agreement with the observations made in Helen Rebola that the principle of balancing between the losses and gains by reason of death and to arrive at the amount of compensation is a general rule. But what is more important is that the receipts by the claimants must have some correlation with the accidental death by reason of which alone the claimants have received the amounts. We do not think it would be necessary for us to go into the question of distinction made between the provisions of the Fatal Accidents Act and the Motor Vehicle Act. According to the decisions referred to in the earlier part of the judgment, it is clear that the amount on account of Social Security as may have been received must have a nexus of a relation with accidental injury or death, so far as the deductible from the amount of compensation. There must be some correlation between the amount received and the accidental death, or it may be in the same sphere. Absence of the amount received shall not be deducted from the amount of compensation. Thus, the amount received on account of insurance policy of the deceased cannot be deducted from the amount of compensation, though amount of receipt of premium is accelerated due to the premature death. So far as the other items in respect of the council has vehemently urged, for example, some allowance paid to the children with so-and-so correlation with, apart from the fact the contribution comes from different sources constituting the fund out of which the payment on account of social security system is made. One of the constitutes of the fund is tax, which is deducted from the income for the purpose. We feel the High Court has rightly disallowed any deduction on account of receipts in the insurance policy, other receipts under the social security system under the claimant, which have also otherwise have entitled to receive irrespective of accidental death of Dr. Mahajan. If the proposition receipts from whatever source is interpreted so widely that it may cover all receipts which may come into the hands of the claimants, in view of the mere death of the victim, it would only defeat the purpose of the act providing for just compensation on account of accidental death. Such gains may, on account of savings or other investments, etc., made by the deceased would go to the benefit of the wrongdoer, and the claimant should not be left worse off if he had never taken an insurance policy or had not made investments for future returns. Thereafter, Milords, yes, Milords.
Is it your case that even after this death, this entire amount of 28,134 is being paid to the widow every month? Just answer this question.
Milords, the daughter and the other Anamika.
I have asked a simple question.
Yes, Lords. Florence Sundi is age 27, a daughter, and Anamika Sundi is also daughter. She is a major.
Is it your case that the amount of rupees 28,134 which the husband was getting as a pension is being paid to the wife even after the death of the husband?
Lords, we have only stated that this amount of pension
should not be considered.
Yes.
For calculating the income.
It is obviously, Lords, upon death, the amount of pension would be family pension would come to her.
I don't know, there is nothing on record. This amount of 28,134.
Yes, Lords.
Is the income of the deceased?
Lords, he was getting pension, yes, Lords.
The income of the deceased?
By way of pension only, my lords.
It may be by way of pension, it may be by way of salary, it may be by way of begging, it may be by way of anything. The income tax return shows that it is on the income side. It is not on the expenditure side.
Yes, my lords. As far as that aspect is concerned, but
Return, it is shown as the income of the deceased.
no, my lords, there are cases.
Listen to me.
Yes, my lords.
First, Mr. Pratish Kumar, the problem is that without going to the facts, you jump to the law. You apply the law 302 in a case of 370. In a case of 420, it cannot be conceived of. First, listen to the facts. If the fact says it's a case under 379 IPC and you apply the law for 302, this court is the last person to accept all these things.
No, my lords. Certainly, my lords. Now, my lords, if your lordship say,
just tell me. Let us understand. This amount of 28,134.
Yes, my lords.
Is the income of the deceased. Yes or no?
Lords, under the Income Tax Act,
Mr. Pratish Kumar, what is the source? It is different. Source may be salary, maybe pension, maybe wagering, maybe X, Y, Z, A, B, C. Just tell me it is the income of the deceased or not.
It would be in income, lords.
It is the income of the deceased?
Yes,
now,
lord.
It is income by way of pension?
Pension.
So, is it your case that this income is even after the death of the deceased, this income is continuing so far as the widow is concerned?
Lords, we have not specifically taken that plea.
So finished? Finished?
But lords, the pension, lords, certainly is a statutory thing to be given.
So,
because
when
it was.
Supreme Court says, when Supreme Court says what pension is being given to a deceased, you cannot deduct it. You are saying that it should not be considered. That means it's a case of deduction over in your case. It's a case of deduction in your case.
Lords, my respectful submission would be that suppose, Lord, there is a family business, and if a person is a Hindu undivided family.
Mr. Counsel, you are comparing a case under Section 379 IPC with a 302.
Lord, this is my respectful submission.
You can make n number of submissions.
No, Lord, if your lordships
I'm giving you opportunity, come up with the facts. If you want, you go make further research. You come up with the facts where the facts at least tallies somewhat.
Yes, Lords, I'll Lords, I'll let it be some other day, Lords. I'll try to assist Lordships, trying to bring out as because. But Lords, the fact remains here. One thing I must say that we have not taken that plea specific, which will what Lordships query which has fallen from your Lordships. That whether
do you want to waste the time of the court?
No, certainly. That's the reason why, Lords, I am saying that if your Lordships has taken a very pointed query to me, that since, Lords, whether you have taken this point or not. So, Lords, I was actually making an argument on the principle of law only. But
first, you would have established the fact that, look, this was a pension. His only income was pension. He was getting a pension of 28,000. And after the death, this lady is also getting the pension of 28,000. Nothing has been reduced. So there is no monetary loss. There is other loss, non-pecuniary damages. You calculate. This is also nothing.
Okay, Lords.
So.
As regards the contributory negligence is concerned, there is an evidence of AW1. Your Lordships may kindly take note of that. That is for your Lordship's kind perusal.
Heard the counsel for the appellant and heard the counsel appearing on behalf of the insurance company. On the request of the parties, this appeal is being disposed of at this stage itself. This stage itself, as the lower court records are available. First off, next slide. The counsel appearing on behalf of the appellant, challenging has made a limited challenge to the award passed by so and so in case number so and so. He submits to the appellant. Counsel for the appellant submits that he is only aggrieved by the part of the award by which contributed in negligence to the extent of 40% has been decided against the appellants. He submits that on the facts of the case and on the evidence which has been led, the tribunal could not have held that the appellant, the deceased, was also negligent to the extent of 40%. He submits that the evidence of the sole witness, who happens to be the eyewitness also, was not considered properly. He submits that the tribunal has proceeded with the notion that the deceased, deceased who was riding the motorcycle dashed against a stationary vehicle, a stationary truck, and thus contributed towards the accident. He submits that if the evidence of AW1 is looked into, it will be clear that the vehicle was not stationary, rather it was being driven in a rash and negligent manner, and it stopped in the middle of the road suddenly, as a result of which the deceased could not maintain his balance. Deceased who was behind the truck, could not maintain his balance and dashed against the truck. He submits that on this aforesaid fact, the finding that the deceased was also negligent to the extent of 40% is absolutely bad. Good stuff. This is the only ground taken by the appellant in this appeal. Good stuff. Next paragraph. Mr. appearing on behalf of the insurance company submits that the vehicle that the deceased was driving his motorcycle in a rash and negligent manner and dashed against a stationary truck. He submits that dashing against a stationary truck will definitely lead to a conclusion that the motorcycle was being driven by the deceased in a rash and negligent manner. He submits that the tribunal has rightly apportioned the compensation amount, has rightly held that there was a contributory negligence to the extent of 40%, so far as the deceased is concerned. He submits that, he further submits that even though the insurance company has not filed an appeal, yet he is challenging the quantum on the ground that the deceased was a pensioner and his pension could not have been the basis for calculating the compensation. He submits that the Honorable Supreme Court, in the case of
Two 2011-14 SEC 639.
In the case of Sebastian Lecra, reported in 19, volume 17, 465, and in the case of so-and-so versus so-and-so, 2014, yes?
2011-14 SEC
2011, volume 14, SCC, page 639. क्या लिखे? Yes, what have you taken down? Who is taking down?
Sir Anjali.
Yes, what have you taken down?
Further submit that even though the insurance company has not filed any appeal, he is challenging the quantum on the ground that the deceased was a pensioner and his pension could not have been basis for calculating the compensation.
I'm not being able to hear you.
He further submits that even though the insurance company has not filed appeal, he is challenging the quantum on the ground that the deceased was a pensioner and his pension could not have been a basis for calculating the compensation. He submits that the Honorable Supreme Court in the case of
And full stop, right, full stop. He submits that in view of the judgment of the Honorable Supreme Court, he can, even though he has not filed an appeal, the insurance company can take the aforesaid plea and get the quantum reduced. Full stop. In support of his both the submission, he relies upon these two judgments. 2019, volume 17, SCC 465, and 2011, volume 14, SCC 639. First up. Parties held that the deceased was also negligible and has contributed to the accident and thus reduced 40% of the amount of compensation which the claimants were entitled to receive. After going through the judgment, I find that the tribunal has held that the deceased who was riding the motorcycle along with his wife dashed against a stationary truck. It has been held that dashing against a stationary truck from behind will naturally lead to the conclusion that the deceased who was riding the motorcycle was rash and negligent, and thus it can safely be, and thus the tribunal has held that there was contributory negligence to the extent of 40% on the part of the deceased. First step. To come to a conclusion whether the said finding of fact is correct or not, I have gone through the evidence led during the during trial. First up, claimant witness number 1 is the wife of the deceased and the claimant herself. Full stop. This claimant oblique witness was accompanying the deceased when the accident had taken place. Full stop. She was a pillion rider. Full stop. She has clearly stated about the manner of accident in paragraph 3 of her deposition. She has stated that on the fateful day, she was accompanying the deceased in a motorcycle and they were behind a truck bearing registration number JH05AF, A for Ahmedabad, F for France, 1514. Full stop. She has stated that the truck was being driven in a rash and negligent manner, and while driving the same, the truck suddenly stopped at the middle of the road without giving any indication or parking lights. She stated that as the truck suddenly stopped in the middle of the road, her husband got disbalanced and lost control over the motorcycle and dashed against the truck. Full stop. This finding dashed against the truck, as a result of which, both this witness and the husband fell down, and the husband sustained injury and later on expired. Full stop. This statement clearly suggests that the truck was being driven and it suddenly stopped without any indication. Full stop. This also suggests that the finding arrived at by the tribunal, to the extent that the deceased dashed against a stationary truck, is not correct. The tribunal proceeded with a notion that the truck was stationary and the deceased dashed against the same, which notion is absolutely incorrect and is not in accordance with the and not in consonance with the evidence which has been led. Thus, next para, thus, on view of what has been found in the evidence, I am of this opinion that the conclusion which the court has arrived, tribunal has arrived, that there was contributory negligence is a wrong finding of fact. Is a wrong deduction on a erroneous finding of fact. Thus, I set aside the aforesaid finding and hold that there was no contributory negligence on the part of the deceased in the entire occurrence. Further, since there was no contributory negligence on the part of the deceased, deduction of 40% of the compensation amount on the ground of contributory negligence is also bad. The claimants are entitled to receive the balance amount of 40% which has been deducted by the tribunal. Next para. So far as the contention of the appellant is concerned, there is no doubt that even if the appellant has, even if the respondent has not challenged the appeal, he can challenge the finding by a separate appeal, he can challenge the findings, some of the findings which goes against him, in an appeal filed by the appellants. But first up, in this case, the appellant is, the respondent has come up with a plea that the pension amount should not be considered and should be deducted and should not be considered in favor of the claimants at the time of for the purpose of calculating the compensation.
Yes. My submission is, since it has already been granted, and once compensation has been granted, then there is no need further to enhance. I'm not saying it should be deducted. My submission is,
where is the question of enhancement? What has been enhanced? Nothing has been enhanced.
No, my submission is that my submission was not for deduction. My submission was that since contributory negligence, if it has to be taken that there is no contributory negligence at all, then even if that aspect would have come into play, would have not made a difference, because the pension should not have been taken. So if pension has been taken, then the amount of on the principle of just compensation.
Company that that even if the issue of contributory negligence is answered in favor of the claimants, the claimants are not entitled for that 40%, not entitled for the balance 40% on the ground that the deceased was a pensioner and his pension amounts, and being a pensioner, this said amount should not be considered. This is your case?
Lords, had it not been considered, then he would not have got what he has got, and thereafter, Lords, certainly.
He submits that as per the judgment of the Honorable Supreme Court, while calculating compensation, the pension amount should not be considered, and that being so, the claimant is not entitled to receive even the amount which the claimants have received. First up, on the aforesaid submission, I am of this court is of the opinion that the aforesaid submission has got no legs to stand. First up, it is the Honorable Supreme Court in the case of Sebastian Lakra has held that whatever amount is being paid by the employee to the employer on account of death should not be deducted while calculating the amount of compensation. Full stop. In this case, the deceased was a pensioner and his only income was the pension. First up, there is nothing on record, nor the insurance company has brought anything on record to suggest that even after the death of the deceased, his widow is getting the entire amount which the deceased was receiving. First up, there is the claim, the submission which the lawyer of the insurance company is raising before this court has also not been raised before the tribunal also. There is no evidence to that effect in support of the submission made by the, in support of the submission which is being made by the claimant. First up. Further, the judgment of Sebastian Lacroix, which the claimant, which the counsel for the respondent is referring to, is in fact, on the facts of the case, is not applicable. First up. Thus, I find that this submission made by the learned counsel for the insurance company has got no legs to stand, and the same needs to be rejected. First up. Next para. Thus, from what has been held above, this appeal stands allowed. The claimant is entitled to receive the deducted amount of how much?
8,10,259.
8,10,259 from the insurance company.
With interest 6%.
First of the said balance amount will carry an interest of 6% per annum from the date of the award, that is 7/11/2017, till the same is paid. It is expected that the insurance company will satisfy the award within 2 months.
Obliged.
Obliged.
Serial number 35 with serial number 36, MN number 116 of 18 with MN number 49 of 19. Mr. G.C. Jha, appellant in first case, Mr. Vivas Sinha, Mr. Anmol Deepak, Mr. Vikrant Sinha, appellant in second case, Mr. Vijay Bahadur Singh, Mr. Vivas Sinha, respondent in first case, and Mr. Vijay Bahadur Singh and G.C. Jha, respondent in second case.
My lords, these are two connected appeals, one by the insurance company and another by the owner of the vehicle. My lords, we see the order number 8 dated. There are IAs, my lords. Therefore, order dated 29th March 2019, my lords may see.
29th March 2019.
Yes. Order number 8.
Order number 8.
Lords, the insurance company was asked to file counter affidavit to the interlocutory application filed by me, which is basically for additional evidence.
Yes, Mr. Jha.
Yes, Lordship. In this case, Your Lordship, after 2000, Lordship, the other appeal which has been filed by the owner of the vehicle, Your Lordship, there is a voluminous documents, and it has come for the first time, Your Lordship. I seek instruction. I want to seek instruction from the company, Your Lordship. So let the case be taken up after 2 weeks, Your Lordship. In the meantime, I will take proper instruction because 3-4 petitions has been filed, Your Lordship. The case was fully.
It's an employee's compensation.
And we have deposited the entire amount, and that has been disbursed also.
Okay. Okay.
So, claimant को इसमें कोई problem नहीं है, Lordship. It is a fight. It is a case between the insurance company and the employer, Your Lordship. Because they have also filed a case, we have also filed. First, we have filed this case.
The claimant has received the fruit of the award.
Lordship,
the claimant has received the fruit of the award.
Yes, Lordship.
Okay. Okay.
Because we have deposited
On the request of Mr. G.C. Jha, this case is adjourned for 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Yes, Lordship.
Obliging.
Serial number 37, MN number 121 of 21, Mr. Alok Lal and Mr. Santosh Kumar for the appellant.
This is an appeal by the insurance company for challenging the liability and the manner in which this case has been set up after the remand. This case was filed before the learned tribunal. The tribunal has dismissed the appeal. So against the dismissal, they preferred a appeal before this honorable court. So, my lord, in this connection, my lord, subject to your lordship's consideration, the record of the earlier case that would be necessary.
Why that will be necessary?
No, in this case, I am coming to that. Reason is that in this case, after the remand, the case before remand, they have
What was
filed.
the nature of remand? What was the nature of remand?
Nature of remand was full remand.
So that means the judgment has been set aside, the matter has been remanded.
Yes. Now let us come to.
Fresh evidence were taken, or it was decided on the basis of the evidence which is already on record?
No, fresh evidence were taken. Fresh evidence was taken. Please bear with me the for moment. In this case, initially, from the date of alleged accident, after 9 months, they filed a complaint case. And on the basis of complaint case, they proceeded. But subsequently, after the remand, how come this FIR and further ban was born? Nobody knows. Nobody knows how this FIR was born, because the tribunal, while before the earlier, has held that they have no file, they have filed complaint case, and on the basis of cognizance was taken.
On remand, the case was a fresh case number was allotted, or it is MACC 38 of 2012.
No, it is the same. It is same.
So it is. There will be only one record. Call for the lower court records.
One more thing, Malad. In this case, let them proceed, and we have paid for stay of execution for the thing also.
Correspondent number 1, 2, and 3. Ordinary process requisites 3 weeks.
Stay.
Why stay?
Execution proceeding, Malad.
Let it go.
Malad, otherwise, whole appeal we will deposit here, Malad. We will deposit here. We are not. But at least that may be kept on hold for some time.
What is
the
stage
parties are
of
concerned.
this? Tell me.
Yes, Lordship.
What is the stage of the execution case?
Malad, in this case, the lower court is pressing hard, and before this pandemic, this was mentioned, but now we have come to know that what are the coercive steps will be taken on the next day. We'll deposit the amount here before the Registrar General. Let them appear. Disability accident has taken place in 2011. The disability certificate which was marked was issued in 2013. And no medical witness has been examined. Before the tribunal, before remand, only 3 documents are filed. Now here, after the remand, kindly see the list of documents. At least 12 exhibits have been filed. 12
Maybe. The earlier judgment was set aside and the matter was again remanded with a direction to take fresh evidence. So
yes,
you have not challenged that.
I'm challenging that now.
No, how can you challenge that now?
Yes.
How can you challenge that earlier?
No, that we have not challenged. That we have not challenged. It was remanded, simply remanded. Now in this case,
I will take it to be a fresh trial.
The fresh ground is that in this case, so far the claim of injury is concerned. Yes. No medical witness has been examined. Exhibit the documents which has been marked as exhibit for injury.
You confine your case to this judgment and how this judgment is wrong and is against the record.
I couldn't get your lordship.
You confine your argument to this judgment and this proceeding itself.
Yes, I'm confining it to it. Now in this case, the exhibit for this so-called disability certificate is of dated 16/1/2013. The date of accident is 2011. No permit has been produced because it was goods carrying commercial vehicle. He was traveling in it. So the permit is necessary for goods carrying commercial vehicle. And so far the injury part is concerned, none of the medical person issued for who was the member of the medical board have been examined. So tribunal, without any those things, have come to finding an 80% disability. And very significantly, Your Lordship, they have first to substantiate the income. In paragraph 11, they have filed the income certificate, which is also dated 27/1/2020. So these are the irregularities which has been done by the lower tribunal after the remand, which should not have been allowed to agitate these matters.
Why? Why not? It is
Why
an
not?
open remand.
It was an open remand. It was an open
What
remand.
is the effect of a remand? Tell me.
Well, I'm not disputing open remand, but the open remand, they should confine themselves to what they have said, because this income certificate is 2020 or 20.
Yes.
So they should have produced their income certificate of 2011, what he was earning. So what is the loss of earning that he has?
Your case is that the income certificate of 2020 has been given, and on the date of accident it has not been given.
Yes.
You confine
Number
it.
one. Number two.
Why are you digging an old grave?
Permit is also not there. Permit is also not been produced, and
Yes.
the disability certificate. So far, the accident is 2011. The certificate which is marked and taken into account is 2013. And that too, no medical expert or witness has been examined.
Show me the earning part.
But that is at paragraph 11 of the award, just before computation.
Court has taken notional income. What is wrong?
Court has taken notional income, that is true. 3,000.
So what is wrong? You were arguing, Mr. Alok Lal, that the income certificate of 2020 was filed.
Yes.
But you
After
did not
remand.
say it was not considered. But you did not say it was not considered.
It was considered on the
No,
basis
it was
of.
not considered. You should have said this is absolutely a point which need not be taken, because the income certificate of 2020 was not considered, was not looked into by the court, giving a finding that it is after 9 years of the incident, so I will not consider. I will take it, the income as a notional income.
3,000 liya hai unhone, notional income.
You have not said that. You give an impression that as if the court has taken
income.
What prevented you from saying this?
Beg your pardon, Your Lordship?
What prevented you from saying this?
No, I'm sorry, Your Lordship. In this case,
you are raising a ground which is non-existent.
No, income test certificate, he has taken the notional income of 3,000, but the thing is that, what was the income in 2011?
So court says there is no income. It cannot be said that the court has said I am taking it 3,000 on the ground that since there is no income certificate, the notional income has to be taken into consideration. What's wrong in it? What is the nature of disability?
Well, they say it is 80% disability. No, this is in paragraph 10.
What is the nature?
Disability.
What is the nature? What is the nature of injury? Tell me.
It is only with regard to 80%, which is clear from exhibit 9.
So tell me, what is the nature of injury?
Let me see if I have the copy of the exhibit. I don't think that the copy of the exhibit is with me. No, but there is no copy of that injury disability certificate in my record. That is not in my record.
Issue notice to the respondent number 1, 2, and 3. Ordinary process requisites 3 weeks. Full stop. IA number 6324 of 2021. The counsel for the appellant claims praise that the impugned award be stayed as an execution proceeding has already been initiated, being execution case number 2 of 21, which is pending before
MSCT Palamu.
MSCT
Dalton.
come additional district judge 2. Full stop. He submits that the respondents are pressurizing to execute the award, and if the award is executed, and in the event the appellant succeeds, it will be very difficult for the appellant to recover the amounts. Full stop. Next para. Considering the aforesaid facts, I direct the appellant to calculate the amount of compensation along with interest as awarded, and deposit the said amount before the Registrar General of this court. First up, after the entire amount is deposited, the Registrar General is directed to keep the said amount in an interest-bearing account. Full stop. Since this since this order has been passed ex parte, awaiting appearance of the respondents, it will be open to the respondent claimants to appear and pray for an appropriate order, including a prayer to release the amount in their favor. Release the amount oblique a portion of the amount in their favor.
But one confusion, whether the awarded amount or with interest.
Awarded amount with interest, I have already passed an order. Awarded amount along with interest. You can keep the amount with you. You can keep the amount with you. Other alternative is you can keep the amount with you, but you have to give an undertaking that henceforth from today onwards, the interest rate will be 12% per annum.
No. That I cannot.
You can use the amount.
No, that we'll deposit.
You can take benefit from that amount.
No, we will deposit. We'll deposit. We'll deposit.
Yes, okay. The IA disposed of. Okay. Over. Board over.